Foreclosure Guide for Beginners: Do's, Don'ts, and Common Defenses to Foreclosure. Foreclosure can be overwhelming, scary, and confusing. The thought of potentially losing your house, coupled with the stress and uncertainty of the situation, could drive you to make serious mistakes, either by taking improper actions or failing to act at all. If you're facing foreclosure, learn what you can and cannot do, and remember there are legal defenses that could possibly stop the foreclosure process. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you are doing fantastic today. I'm doing marvelous. And if you're doing as great as I am, go grab a cup of coffee or tea or vodka. Today I'm going to talk to you about foreclosure, the do's, don'ts, and the common defenses to foreclosure. Now, before we get into the nitty-gritty, let's understand the foreclosure basics here. Now, when you have a home loan transaction, there are some parties involved, right? So you have the borrower. So this is you, the individual who borrows money and pledges the home as security to the lender for the loan, right? So the borrower in legalese, in legal terms, is sometimes called the mortgager. Then you have the lender. So the lender is the institution which originates the loan, right? The lender is called the mortgagee. And then you have the investor, right? So sometimes you have an investor may buy loans from lenders. So Fannie Mae and Freddie Mac are considered investors. And there are other non-government backed investors also, particularly investment banks and hedge funds and all kinds of financial institutions that also engage in buying mortgages. And then you have the servicer. Now the servicer is the company that you make the monthly payment to. They're the one who handle the loan account. Now you have to understand that sometimes the servicer is not the lender. It is a third party that manages the account on behalf of the lender or an investor, and they charge a fee to the latter. All right. So servicers' duties might include collecting and processing loan payments, initiating and monitoring a foreclosure when a borrower stops making payment, for instance. All right. Now, another thing you need to understand here when it comes to a home loan transaction is there are three things. The promissory note. Now, the promissory note is essentially the documents that contains the borrower's promise to repay the amount borrowed. Think of it as an IOU, right? And then you have the mortgage and deeds of trust. Now, mortgages and deeds of trust give the power to foreclose. In other words, now, a mortgage in some states, a deed of trust. The words mortgage and deed of trust are interchangeable. Now, the mortgage is the contract that gives the lender the right to foreclose if the borrower doesn't make payments on the loan as agreed, right? Now, and then now you have something called endorsement and assignments. Now, promissory notes are transferable. In other words, banks often buy and sell home loans, right? As I said earlier, Freddie Mac and Fannie Mae are not the only investors. So when a loan changes hands, the promissory note is endorsed. It's signed over to the new owner of the loan. So the seller documents the transfer by recording an assignment of the mortgage or deed of trust in the land records. Now let's talk now about foreclosure steps. If you default on your loan by falling behind payments or you breach the agreement in some other way, the servicer will probably refer the loan to an attorney or trustee, right? Now, there are two types of foreclosure. You have something called judicial foreclosures. Those go through court. So in a judicial foreclosure, a lawyer files a lawsuit on behalf of the lender or investor in court to foreclose the home. So you'll receive a copy of the complaint. Sometimes this is called a petition, and this is the first step in the foreclosure process. Now, from that point on, you get a certain number of days, like 30 or 45, to respond to the lawsuit. So if you don't file an answer in court within that time frame, or if you file a response but the court decides the foreclosure should go ahead, the court will grant a judgment of foreclosure in favor of the foreclosing party and set a sale date. Now, the foreclosure sale, it's typically an auction where the public as well as the foreclosing party may bid on the property. The highest bidder becomes the new owner of the home. So that's for judicial foreclosures. Now you also have non-judicial foreclosures. Those generally do not involve any court action, right? All states allow judicial foreclosures, but about half also permit non-judicial. That's what they call power of sale foreclosures. In a non-judicial foreclosure, a lawyer or trustee completes certain out-of-court steps. For instance, they mail the borrower a notice of default that tells how much time the borrower has to reinstate. In other words, they have to get caught up on payments. They record the notice of default in the local land records office, and they mail the borrower a notice of sale that states when the property will be sold. Like in a judicial foreclosure, the property is usually sold at a public auction. So depending on state laws, a borrower might get a combined notice of sale, and of default, right? Depending again upon the states where the person is located. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Q. Now let's talk about the do's and don'ts of foreclosure. Now, if you just been listening to us and you believe that we're adding value to your life, please consider subscribing to our channel and turn on the notification bell so that whenever we drop a new show, you can receive it and you can find it valuable. Also, comment below, share, and like. Now, one thing is very important. This is a disclaimer. We're not providing legal advice here. If you want to fight a foreclosure, consider hiring an attorney to represent you. If you cannot afford to hire an attorney to represent you throughout the entire process, you want to consider at least scheduling a consultation with one who can help you decide what to do. And they can tell you how foreclosure works in your state and explain your legal rights and responsibilities. Right? So the Sweetie Kiwi Show provides a general picture of how foreclosure works, but laws vary from state to state. All right. So again, reach out to a specialist, a legal specialist who can help you. Now, the do's. When it comes to foreclosure, here are the things you should do. Contact your mortgage servicer. So if you're falling behind, as soon as you think you're going to have trouble making your monthly payment, or shortly after you fall behind, call your servicer. Right? So you want to talk to them, explain the situation. You might be able to work out a forbearance agreement or a repayment plan. The next thing you want to do is you want to contact a HUD-approved housing counselor for assistance. HUD stands for the Housing and Urban Development. This is an agency of the United States government, and they have counselors, they have housing counselors who will be able to help you. So you can apply if you want to apply for a foreclosure alternative, like a loan modification, a short sale, or deed in lieu of foreclosure. A HUD-approved housing counselor can tell you more about these options. They can also evaluate your financial situation and help you deal with your servicer. So they're basically in your corner here. Another thing you want to do is you want to find out how foreclosure works, right? Because the laws are different. The laws vary from state to state. And depending on state law and your circumstances, your foreclosure could be judicial or non-judicial, right? We already talked about that. So you want to learn ASAP each step in the foreclosure process so you aren't caught off guard at any point. Additionally, find out about federal laws, right, and state laws that can protect you while you're in foreclosure. There are laws out there. Of course, you have responsibilities as a house owner, as a homeowner, but you also have rights. You want to make a record of all your communications with your servicer, right? So you really want to keep track of when you call, whom you spoke to, and what you talked about. It's very important that you really, because this will be critical in court if the matter should go to court. So ideally, lawyers will advise their clients to keep a folder with all correspondence from the lender, servicer, court, or foreclosure trustee. That way, you have a clear idea about the status of your case, right? And also, you might have a defense to the foreclosure if you don't get certain documents. I'll talk about that later on. You want to participate in foreclosure mediation in your, if your state, county, or city offers it. Now, this is a great tool. This is a great platform because foreclosure mediation typically brings the borrower and lender or its representative to the table, along with a neutral mediator, right? And the goal here is to work out a way to resolve the delinquency, right? So this is a great tool. The last thing you want is to end up in court or in a foreclosure. So if there is a foreclosure mediation process, take advantage of it. Another thing you want to do is to find out if your state has a hardest hit fund program. Now, this is a program this type of program is called HHF, hardest hit fund program. This kind of programs offers financial assistance to homeowners, right? So you could qualify for money to get caught up on the loan or pay future mortgage payments, for example. And one last thing you want to do is avoid foreclosure rescue scams, right? Unfortunately, there are a lot of folks who are out there, a lot of companies who want to prey on very vulnerable homeowners, right? So you want to be wary of letters and phone calls from, lucrative companies, especially companies that offer to help you, get a loan modification, right? Now, these companies might send you very official looking letters and correspondence, right? And they have great sales pitch, but they are usually scammers. Companies that offer to stop the foreclosure for a fee are often scammers. So you want to really stay away from there. Now, so we talked about the do's, right? Now let's talk about the don'ts. Do not ignore phone calls or letters from your servicer. All right. So any kind of correspondence that originates from your servicer, you want to pay attention to it, because calls and letters from your servicer will likely explain any options you have to avoid a foreclosure and how to apply for those options. Remember, the servicer does not want a foreclosure either, right? They don't want to lose money and go that far, so they're trying to work out something with you. So you need to pay attention to the correspondence. Don't ignore letters from the court or a foreclosure trustee. Same thing, right? Because this type of correspondence will have, any important information like the sale date and details about your rights during the foreclosure. Don't assume the servicer is always correct, because servicers are well known for making mistakes that violate the law when processing foreclosures, right? So you should understand the specifics of both federal and state foreclosure laws and procedures. So in case the servicer messes up, you could have a defense to the foreclosure. Don't wait until the foreclosure is almost over to try to save your home, right? Because you have more options if you address the problem early on. The longer you wait and the further you fall behind payments, the fewer options you'll have. Don't pay upfront fees or fees for help that you can't get for free, right? It's very important that, as I said this earlier, you have quote unquote a foreclosure rescue company that asks for a hefty upfront fee. Don't go for that. It's better just to contact someone who works for the federal government, like I said, a HUD-approved housing counselor, for example, who will help you without charge. All right. They can also help you apply to the hardest hit fund program if you qualify for it. Don't make your mortgage payments to anyone other than your mortgage servicer. Again, do not fall for the scams whereby the foreclosure rescue companies will ask you to send the money to them for them to deal with for them to actually relay that cash to the servicer. You don't want that. Don't move out early. Do not abandon your house. because if you abandon your home, you'll miss out on the chance to stay there for free during the foreclosure, right? So also, in order to qualify for assistance, homeowners usually have to be living in their home, right? Also, keep in mind that you're still responsible for the property until the foreclosure ends, even if you aren't living there. All right, so this is very important. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. I'm very happy to have you with us today, and we're still talking about do's, don'ts, and common defenses to foreclosure. Again, I want to repeat this disclaimer. Please, this is not legal advice. It's important that you consider hiring an attorney to represent you. And if you cannot afford to hire an attorney to represent you during the foreclosure process, you want to schedule a consultation with one who can help you decide what to do, tell you how foreclosure works in your state, and explain your legal rights and responsibilities. All right, now, after foreclosure, there are a few things you need to pay attention to. You have something called the right to redeem and deficiency judgments. Now, this is very important because you own your home up until the foreclosure sale, right? So you may legally stay in the property until this time. Now, depending upon the state where you live, you might be able to stay in the home until the redemption period expires or until some other action, such as ratification of the sale, occurs. Now, what is the redemption period? Now, some states have laws giving a foreclosed homeowner the right to regain ownership of the home, and this is called redeeming. So after the foreclosure process expires, the homeowner can redeem the property. Okay, so this allows the homeowner to stay in the property by reimbursing the buyer for the amount paid at the sale or by repaying the full amount of the mortgage debt. And so that's for redemption period. What is a deficiency judgment? Now, sometimes a foreclosure sale doesn't bring in enough money to fully repay the home loan. When this happens, the difference between the sale price and the amount owed is called a deficiency. In some states, the foreclosing party can get a personal judgment, a deficiency judgment, against the borrower for this amount. What that means is, in simpler terms, let's say you have you have a mortgage of $200,000, for instance, and the house after foreclosure sells for $150,000. The difference of $50,000, that's a loss to the servicer. I mean, that's a loss to the investor, right? So in some states, the court can actually enact, if you will, a deficiency judgment, can pronounce a deficiency judgment of $50,000 against you, the borrower. So you still have to pay the $50,000 to the investor. Now, the thing here is that sometimes re-foreclosure is necessary to clear up title to the property. So, homeowners often face back-to-back foreclosures when the title of the property has problems after the first foreclosure. So the second foreclosure is called a re-foreclosure. Now, let's talk about some common foreclosure defenses here. And again, if you talk to an attorney, they might be able to help you raise one or more different types of defenses as you're going through the foreclosure process. Now, you have, and here are a few common foreclosure defenses. The foreclosing bank didn't follow state procedures, right? So if they don't follow it, then a judge might actually throw the case away, the case out of court. The foreclosing party cannot prove it owns the loan. In other words, it lacks quote unquote standing, right? Because only the loan holder, the loan owner, or someone acting on the owner's behalf may foreclose. If the foreclosing party cannot prove it owns the loan, then it doesn't have standing to foreclose. Next, the mortgage servicer made a serious mistake. Now, Mortgage servicers make mistakes all the time when they're dealing with borrowers and their accounts. So you might be able to challenge the foreclosure based on mistakes such as crediting your payment to the wrong party, dual tracking, in other words, pursuing a foreclosure at the same time a loan modification or other foreclosure avoidance option like a short sale or deed in lieu of foreclosure is pending, imposing excessive fees or fees not authorized by mortgage contracts, or substantially overstating the amount you must pay to reinstate your mortgage, right? So these are some abuses that are some abuses and errors that are made by the mortgage servicing industry. Another type of common foreclosure defense is if you are a service member on active duty. So if you are on active military duty, there is something called SERVICEMEMBER, so that's the Service Members Civil Relief Act, provides you with special protections. Most importantly, if you took out your mortgage before you were on active duty, your foreclosure must take place in court, even if foreclosures in your state customarily occur outside of court, unless the lender gets a waiver from you. All right. So, if a military member gets a mortgage after going on active duty, the SERVICEMEMBER provides certain foreclosures protections too. Another common defense to foreclosure is if the statute of limitations has passed. So if a significant amount of time lapses between when you stop making your mortgage payments and when the lender initiates a foreclosure or restarts one against you, the action might have violated the statute of limitations. When applicable, the statute of limitations can be a strong defense against a foreclosure. All right, so this is basically a few common defenses to foreclosure you can invoke in court to win. Now, of course, a lawyer might be able to give you more info about what applies to your particular situation. And this is why, again, we strongly advise you to contact one. Here's a recap of today's conversation, folks. Today, I spoke to you about foreclosure basics, foreclosure steps, the do's, the don'ts, after foreclosure, what is the right to redeem, the deficiency judgments, and what are the common foreclosure defenses. I will speak to you another time. Good luck and stay marvelous.